28-year-old Mount Vernon man Andrey Chuprinov was found guilty of first-degree rape of a child, second-degree rape of a child, third-degree rape of a child, and first-degree incest for the crimes committed against his half-sister. He is now appealing his convictions, arguing constitutional error. During an interview by law enforcement, Chuprinov admitted to having sexual intercourse with his half-sister, but remained silent in response to several other questions. During the trial, the state elicited testimony from the officers about Chuprinov's failure to respond and encouraged the jury to consider the reasons why he remained silent. Chuprinov argues constitutional error occurred when the state commented on his silence. Let's take a look.
Washington versus Chuprinov.
I'll reserve 4 minutes for rebuttal. Good morning, Your Honors. May it please the court, Casey Granis on behalf of Mr. Chuprinov. Things happened in his criminal trial that should happen in no criminal trial. They deprived Mr. Chuprinov of a fair one. Whether we look at it as a matter of the prosecutor injecting reversible error into the case, or whether we look at it as defense counsel failing her client and providing ineffective assistance and failing to object to these errors, either way, the result is the same. The convictions should be reversed. I'd like to first turn to the prosecutorial misconduct that occurred in closing argument, where the prosecutor told the jury that it could rely on their emotions to inform them of whether to believe the complaining witness's testimony, MS's testimony. Highly problematic in a case where the credibility of the alleged victim was a central issue at trial. And this is why the prosecutor made this argument. The prosecutor realized that credibility was a central issue at trial. The problem is that the prosecutor misstated the law, urging the jury to reach a verdict on the basis of a basis other than a reasoned intellectual application of the law to the facts. There was no objection, unfortunately. There was no objection to this blatant misconduct. And that's why Mr. Chuprinov has alternatively framed this argument as ineffective assistance. We say state v. Stotts in the briefing. Stotts is helpful.
Counsel, can I ask you a question about the comment on the right to silence?
Yes.
So you indicate that the appropriate review is the constitutional harmless error review.
Correct.
It looks like, as far as I can tell, that the times that the questions that were not answered had to do with whether there was a use of force. Should it enter into our analysis when considering constitutional harmless error that these are child rape charges that don't involve the use of force?
No, I would not look at it that way. I don't think that's the appropriate framework to look at it. I mean, when we're talking about application of constitutional harmless error analysis, whether there is an error of constitutional magnitude here and commenting on silence, it's not turning on the niceties. When we look at the case law, they're not turning on the niceties.
So I'm not talking about the legal analysis itself. I'm talking about the constitutional harmless error analysis. So is there overwhelming evidence that would show that the jury would have found, or we could conclude beyond a reasonable doubt with regard to guilt, if the issue is the use of force, and the comment was about the use of force, and the comment in closing was about the use of force, but use of force is not an element. How do we deal with that when we're going through the constitutional harmless error analysis?
I see. When we look at how this comment on silence occurred, when we look at the detective's testimony first and foremost, yes, there is, as I recall, reference to Mr. Chuprinov not responding when asked about use of force. But it also, the testimony goes beyond that, though. In other words, not just about whether he used force or not. The detective was pressing for details. Mr. Chuprinov refused to answer when pressed for those details, and then ultimately just refused to answer at all, which terminated the interrogation. And then when we go to closing argument, when the prosecutor again returns to this, exploits this testimony from the detective about Mr. Chuprinov not answering certain questions, again going beyond just, well, okay, did you use force or not? No, it goes beyond that. And the prosecutor, quite skillfully, if perversely, used that partial silence against Mr. Chuprinov to argue, look, essentially arguing, look, is this, would an innocent person not respond to these questions? Would an innocent person refuse to respond? And that's And in a case where we're talking about constitutional harmless error, was the evidence overwhelming beyond a reasonable doubt? It can't be in a case where really it came down to the credibility of the witness, of the complaining witness. As I pointed out in the briefing, MS's testimony, there was a reason to doubt its veracity. Defense counsel, or rather, we look at some of the inconsistencies. She had trouble with some timelines and inconsistent statements.
So counsel, that is often the case in these kinds of cases, right? So is it going to play out that any time that you have a comment on silence in this kind of case, that the state can never satisfy that harmless error test?
No, I'm not advocating for a per se rule, Your Honor, but what I will say is that in a case where it's in a child sex case where credibility of the complaining witness is essential because there's no independent corroborating eyewitness testimony, that the outcome is especially vulnerable to this type of error, to the comment on silence error. And well, I'll leave it there. And when we look at we apply that harmless error analysis to the facts of this case, reversal is mandated. Thank you.
Good morning. May it please the court. My name is Rosemary Kaholakula, representing the state of Washington through the Skagit County Prosecutor's Office. I'll go straight to issue 3, which is whether or not the prosecutor in this case violated Mr. Chuprinov's constitutional right to remain silent. And if so, what is the standard of review? I would first point out that the state's position is that there was no impermissible comment on the defendant's right to silence. The prosecutor was pointing out through questioning and through closing that there were some things that Mr. Chuprinov was saying, but he was willfully withholding details from those things.
So, counsel, I'm just going to tell you, I have a real issue with that argument, because if you look at Young, in Young, the officer wasn't asking him any questions. He was sitting in the back of the patrol car, spewing information. And the question was was about things that he did not say. You have a right to choose not to answer questions at any time. That is your constitutional right. Here, the defendant was asked a question and chose not to answer it. Doesn't that fundamentally distinguish it from Young?
I think you have to consider it as a whole, and you have to also consider the findings that he never invoked his right to remain silent.
Isn't that invoking your right to remain silent? And if there's no finding to it and there wasn't an objection to it, then don't you just fall into the ineffective assistance of counsel side of things?
I don't think you do. I think that once the court found that he never invoked his right to remain silent throughout the entirety of that proceeding, just because he chose not to answer 1 or 2 questions within the entirety of the interrogation doesn't mean he has suddenly invoked his right to remain silent. The finding at this level is that he had never invoked his right to remain silent.
It means that he didn't want to answer the question, right? He chose not to answer the question.
After speaking substantively about the crime.
Sure, and our law says you can speak substantively about the crime and you can choose not to answer other questions.
And the state has the right then to comment on that.
Tell me which case tells you that.
It's cited in my briefing. And I'm relying on state versus, I believe, Clark, Young, and Curtis.
Well, I just told you why Young doesn't apply. And in Curtis, there was actually a finding that somebody did not invoke their right to remain silent, right? And here, first of all, I don't think the findings say that he never invoked his right to remain silent. It says that he waived his Miranda warnings, which is a very different thing. And we have a question that he refused to answer, and a prosecutor who said that his refusal to answer that question means that you can use that as evidence of guilt.
The prosecutor did not say that. The prosecutor said you can use that to determine his credibility in making the argument that the admission made by Mr. Chuprinov was not the entirety of what had happened. So I do not agree that the prosecutor
Chuprinov did not testify. So,
Right, but-
how is it? They're not impeaching him with this. Isn't it substantive evidence of guilt?
No, because the jury was permitted to consider the statements that he made to law enforcement during the interrogation.
But it's not a statement. It's refusal to answer a question. That's the evidence that she was pointing to say that the jury could use against him.
And in answering Judge Chung's question, the entirety of the statement is, the question was, I'm sorry, I think I forgot your question, but what I'm trying to say is that the prosecutor was not saying he stopped talking, therefore he's guilty. The jury was entitled to consider the statement of, yes, I did do child rape 3, but I did not do 1 and 2, which is
Isn't
implied.
that exactly what the prosecutor said? Why do you think he didn't answer these questions? What's that supposed to mean?
It's supposed to have the jury look at the credibility of the statements that Mr. Chuprinov made to law enforcement and considering whether that was the entirety of what had happened in committing the crimes against the victim in this case. So it's the state's position that the prosecutor did not impermissibly comment on the failure to provide details to those things where Mr. Chuprinov was substantively addressing what had happened. This is not a situation where Mr. Chuprinov was saying, nothing happened, or I'm not going to talk about the crime. He was talking about the crimes.
So I think your time might be better used talking about why this would not be constitutional, why this might be constitutional harmless error.
In terms of what the standard of review is, whether it needs to be.
Well, let's presume for the purpose of this argument that we have determined that the standard of review is constitutional harmless error.
Okay.
Why is this constitutional harmless error?
Because in this particular case, there was corroboration that the crimes alleged happened. The corroboration is that the victim gave similar statements to multiple law enforcement officers. The victim gave statements to her cousin, which were verified. I list the examples in my briefing, but the victim indicated that she had gone on birth control because she was concerned about being raped by the defendant. That is corroborated by the cousin. The victim said, I told my mother and father what was going on. That was corroborated by them. She said, during one of the incidents, I had the pink t-shirt across my face. That is corroborated by finding that. In essence, those things that she said happened that can be corroborated were corroborated. The birth control, telling the parents, Mr. Chuprinov being kicked out of the house. In addition, she gave prior consistent statements, which is corroborative. In addition, I think the court can consider the fact that the prosecutor's comments in closing were brief in light of the entirety of the argument, and the testimony on that was brief as well. So I believe it is constitutional harmless error, harmless. I will then briefly turn to the first issue, which is the argument that the prosecutor made improper arguments in closing statement. The standard of review is an abuse of discretion, and the defendant must show comments were improper and prejudicial. The comments that were made here are very different from those comments that were made in State versus Craven. In State versus Craven, the prosecutor basically argued that if it feels right to convict, then you should convict, and this was obviously improper. In State versus Kasparova, which is an unpublished decision, the court distinguished Craven, noting that even though similar words were used, the prosecutor did not make that same argument. Here, the prosecutor did not say you should convict Mr. Chuprinov if it feels right.
There's a difference between if you feel like you should convict, then you should convict, and if you feel like they're a liar, then they're a liar. Or if you feel like they're telling the truth, then they're telling the truth.
She said that you can consider your reaction to the witness's testimony, which is an accurate statement. The instruction tells the jury you can consider the demeanor of the witness while they're testifying. You consider how they testify. You can consider whatever else basically is important to you, which is what the instruction says. The prosecutor further accurately reviewed all the instructions that were provided to the court. She discussed the actual evidence that bore on MS's credibility. She discussed the reasonable doubt instruction as it was written in conjunction with determining the credibility of the witness, and she repeatedly referred the jury to the testimony and the instructions. She never made any inference or implication that the emotions would substitute or take the place of evidence, or that a verdict should be based on anything other than the evidence.
But didn't the prosecutor say that their emotions could be used to guide them in determining credibility
Of the witness? Yes, but then she immediately referred back to the actual instructions which were provided by the court. So I guess that leads into whether or not, if this was an improper comment, was it prejudicial in light of the failure to object? And the question then becomes whether a curative instruction would have cured any resulting prejudice. And I do not believe that the defendant has made that showing. For that reason, I believe that issue number 1 fails. Issue number 2, I'm not sure if you want me to go into that or one of the other issues in my last 45 seconds, but I would indicate, as I did in my briefing, that given the context of the question, there was not an opinion that was made that the officers thought that the victim was telling the truth. Rather, the question was, what was her demeanor? And the officers responded to that question as to their observations of demeanor. And in light of other cases, which said that the following were not comments on credibility, such as in Kirkman, where the doctor testified that the victim gave a very clear history with lots of detail, a clear and consistent history. In Majors, the officer testified that the victim was, quote, obviously traumatized. And in Phillips, Talavera, and Savannah, there were similar statements where the court found that those statements did not constitute an opinion on the credibility of the witnesses. So the state does ask the court to affirm all of the convictions. Thank you.
Thank you.
I'd like to turn to the constitutional harmless error analysis in relation to the comment on the right to silence. State's argument is, as I understand it, is essentially that, well, yeah, this constitutional error was harmless because MS's testimony was that sex that occurred was corroborated. But nearly all, there's no real corroboration here, at least as far as the first and second degree rape charges, because really all we have in relation to those is MS's say so. Yes, she makes various statements over time, but it all comes down to, okay, well, is she telling the truth when she's making those statements? Repetition of a statement that something happened does not equal veracity. Our case law clearly establishes that. We do have an admission by Mr. Chuprinov during interrogation that he did have intercourse with MS, but recently, so that would go to the third degree rape charge. Okay, so there's some corroboration there. But even so, as I point out in the briefing, Mr. Chuprinov did not go into detail. MS did in her statements and in her testimony. And so the jury was still tasked then, as a matter of jury unanimity, of deciding on a particular act that occurred for that third degree rape charge. And so again, it comes back then to the credibility of MS's testimony, the corroboration. Is there any corroboration of any of the detailed acts that MS described? No. And I will also point out, as the state did in its response brief, that even for the incest charge, where there's a special verdict on that one, that the incest occurred when MS was under 14 years of age. So again, the age component here is pretty significant. We don't have any real corroboration outside of MS's testimony and statements that this incest occurred before she was age 14.
Could you address your sufficiency of evidence as to the incest charge, that
Right.
argument.
So the state needed to prove as an element of its case that there was a biological relationship between Mr. Chuprinov and MS, and also had to prove that Mr. Chuprinov knew of that relationship. The evidence is lacking here. Really, we have speculation in place of real evidence that would support a conviction. We've got some generic testimony identifying, Sergei as the father of both Mr. Chuprinov and
Why
MS.
isn't that enough?
Because that testimony does not speak to whether that he is the biological father of either one of them. Certainly.
Are you suggesting that something scientific evidence or proof of paternity is required?
No, not necessarily, although that would do it. But if Sergei had testified, well, I am the biological father of Mr. Chuprinov, and I am the biological father of Anas, for example, I think that probably would be sufficient. If he can competently do that, he can offer that type of testimony. There's just a gap in the state's case, though. I mean, the state really dropped the ball in this respect. It didn't elicit what may be the truth, may be a fact out there, but just didn't do it. Just overlooked it. State relies on the presumption of paternity. Jury wasn't instructed on that presumption, but even if it applies, again, the evidence fails. You don't have the evidence to show that Mr. Chuprinov was born when he was born in relation to the marriage, and the same goes for MS in relation to the second marriage. So yes, the incest conviction should be reversed due to insufficient evidence. Thank you.
Thank you, counsel.
Following these arguments, the court reversed the convictions for rape of a child in the first degree and rape of a child in the second degree. They also reversed the special verdict on whether the victim was under the age of 14 at the time of the offense of incest in the first degree. They did affirm the convictions for rape of a child in the third degree and incest in the first degree. What do you think of this case?